to move Kanu'S terrorism trial to a new venue. Welcome to the news and thank you for tuning in to listen. The Federal High Court in Abuja is set to move the venue of a trial of the indigenous people of Biafra, IPOB leader Nnamdi Kanu, to the Court of Conduct Tribunal headquarters in Abuja. It is in reaction to complaints about the discomfort experienced during proceedings in Kanu'S treasonable felony trial, which attracts many security agents. The decision is contained in a new set of practice directions on hearing of terrorism cases issued by Chief Justice John Soho. The court spokesperson Catherine Obi Christopher said in a statement that the practice directions to be cited at the Federal High Court Practice Directions on Trial of Terrorism Cases 2022 takes immediate effect. Justice Soho, in the practice to the directions, said he issued the directions in the exercise of a powers conferred on him by Section 254 of the Constitution. Order 2 deals with direction on trial proceedings. It provides the parameters of a court sitting over a terrorism trial shall be secured for the period of the trial for the safety of litigants and court officials. Distance and size of perimeter to be secured for the trial shall be determined based on recommendation of security agencies on a case-by-case basis. No person shall be allowed within the secured perimeter save the approved court officials, parties, and a member of the pre-registered legal practitioners on the other side, witnesses, and any other person as may be directed by the judge or the most senior judge in the given circumstances. Only the judges or the essential court staff and security agents involved in the particular case and their vehicle shall have access to the court's premises. Also yesterday, Kanu filed a fresh suit before the Federal High Court Abuja demanding his unconditional release. Kanu in the suit marked FHC ABGSCS 462-2022 is also claiming 50 billion naira damages and 100 million naira as the cost of the suit. He argued that he was abducted in Kenya by the Nigerian government agents, brought to Nigeria, and kept under unlawful custody. The federal government and the Attorney General of the Federation, AJF, are the defendants. In the suit filed by his legal team, led by Mike Ozekome-san, Kanu wants the court to declare that his abduction and extraordinary rendition to Nigeria without being subject to extradition proceedings or hearings in Kenya, where he was abducted, is a clear violation of Article 12.4 of the African Charter on Human and People's Rights, Ratification and Enforcement Act, CAPA9 LFN 2004. He also wants a declaration that his continued detention on the strength of an amended charge filed after his extraordinary forceful rendition to Nigeria are illegal, ultraviolates the powers of the defendants, and a violation of the first defendant's rights under Nigerian municipal laws, African Charter on Human and People's Rights, International Covenant on Civil and Political Rights, ICCPR, the Convention Against Torture, its operational protocol, and unconstitutional right of a plaintiff, and the UN Declaration of Human Rights, UDHR 1948. The plaintiff is praying for an order directing the defendant to unconditionally release him forthwith from the custody of the Department of State Services, DSS. Kanu is also praying the court to restrain the defendant and the agent from taking any further step in the prosecution or trial of the plaintiff in criminal charge number FHC ABJCL 3A3 2015, currently pending before court number 2, Federal High Court, Abuja. He wants the court to issue an order of perpetual injunction restraining the defendant and their agent from further persecuting or from other inciting any criminal proceedings or any action against a plaintiff, or from further arresting or detaining the plaintiff on the same or similar offences. In a supporting affidavit, he stated that he is an indigene of Isiama Afaruku Ibeko in Umuahia North Local Government area of Abia State and was born on the 25th of September 1967. He added that after he was granted bail on April 14, 2017 in the criminal charge number FHC ABJCR 3A3 2015, and the matter was consequently adjourned to the 17th day of October 2017 for hearing. While the plaintiff was in his ancestral home at the Afaroku, Abia State, enjoying the bail granted him by the court and preparing for his trial scheduled for the 17th day of October 2017, the joint team of security agents led by the soldiers invaded the said ancestral home of the plaintiff on the 10th and 14th of September 2017. In the course of involuntary exile overseas, the plaintiff on the 5th of May 2021 entered the Republic of Kenya and was legally admitted into the country. After his admission, the plaintiff took up to a temporary residence in the location in Nairobi, Kenya. On the 19th of June 2021, the plaintiff drove himself without any companion to Jomo Kenyatta International Airport, Nairobi, Kenya, on a personal engagement. Immediately, the plaintiff pulled a stop at the parking lot of the airport and alighted from his vehicle. About 20 agents of the defendant violently accosted and brutally abducted the plaintiff, handcuffed and blindfolded and bundled him into a waiting vehicle and immediately sped away. The plaintiff abductors took him to a nondescript private house, not a police station or other official holding facility, somewhere in Nairobi, Kenya, and chained him to the floor. The plaintiff was not shown any warrant of arrest issued by any court in Kenya or any extradition warrant. He also was not informed of the existence of any such warrant or the reason for his unlawful abduction. Throughout the duration of the plaintiff's cruel captivity, he was not allowed to bathe and was fed only with a bland bread once a day and given non-salutary water to drink. The inhumane treatment, cruelty, and vicious degradation the plaintiff's abductors subjected him to, and external and internal injuries he sustained therefrom, coupled with his poor health, made the plaintiff live in dread, fear, anxiety, terror, and apprehension that he was going to die in captivity. All the plaintiff entreaties to his abductors to avail him medication for his hypertension and heart condition were inhumanly refused by the said agent of the defendant. All the plaintiff's entreaties to be taken before a Kenyan court or even a police station or other official law enforcement facility to or allowed to make a phone call were not only roundly rejected but were met with more beatings and torture by his abductors. On the 8th day, the plaintiff abductor brought him out of a house, put him in a car, drove him straight to the tarmac of Jomo Kenyatta International Airport, where they skillfully evaded Kenyan immigration and forcibly bundled the plaintiff into a private jet that departed the airport at about 12 noon on the 27th of June 2021 and arrived in the evening of the same day. Wow. Wow. So at the end of the day, I just hope Mr. Nnamdi will place again, because right from the beginning I've said I don't understand why they're still keeping this man in detention, and I also don't understand why they are actually not looking at the fact that he was treated this way, when he was, or during when they were bringing him into Nigeria. Okay, let's hope he gets justice. On this note, we've come to the end of the news. We say thank you for tuning in to listen. Until I come here next time, enjoy the rest of the day.